Okay, guys. Someone had requested that I do a video on Spank. I think her first name is Karen. I just don't have it in front of me right now. But I actually happened upon this accidentally. And interestingly enough, Jesse Prince talked about how Scientology and Scientologists would actually threaten judges, intimidate them, pay them off, all kinds of things. Is that called judge tampering, or there's an official word? I'll have to look it up. So this is from Scientology Criticism. I believe they sourced this from the American Lawyer. Remember when we used to source things and read and cite our papers? December 1980. Scientology's War Against Judges by James B. Stewart, Jr. Imagine that this is out here. Yet Clearwater, not all Clearwater PD, but some of the Clearwater PD are just like, ugh, you can't truck outside of here, even though it's legal. But they can't seem to get a hold of articles like this. Things that make you go, Are you shoving one of your pant legs up to the knee? Inquiring MF minds really want to know. On September 5th, 1980, as U.S. District Court Judge Charles Ritchie was recuperating from 2 pulmonary embolisms and exhaustion, lawyers for the Church of Scientology, I'm sure Moxie was in there, and the Justice Department, in name only maybe, gathered before Judge Aubrey Robinson, Ritchie's successor in the 2-year-old conspiracy case against 11 members of the Church of Scientology. Judge Ritchie had already convicted and sentenced 9 of the original 11 defendants. But the remaining 2, recently extradited from England, were about to go on trial, particularly from the standpoint of Your Honor's feelings about these defendants who are members of the Church of Scientology. Began John Shorter Jr., a lawyer for one of the defendants. He was interrupted by Judge Robinson. You want to raise a motion to recuse? The judge asked. He knew what Shorter's remark foreshadowed, having witnessed the Scientologists campaign to drive Judge Ritchie off the case. Is this a fishing expedition? Robinson is the 4th D.C. District Court judge to preside over the Scientology case and the latest target of the Scientologists' self-proclaimed attack litigation strategy. It's going on now with the Haney case. Their strategy amounts to an all-out war against the D.C. District Court judges. Isn't that illegal, everyone? FBI. Is that illegal? Unlawful? Against the law? A war much more sophisticated, better financed, and more successful than the bizarre tactics used by some other groups against their courtroom adversaries, such as Synanon's attempt to murk an opposing counsel by putting a rattlesnake in his mailbox. Unlike Synanon, the Church of Scientology has long sought to distinguish itself as a legitimate religion. Founded in 1954 by L. Ron Hubbard, a science fiction writer, philosopher, and author of the best-selling book Dianetics, The Modern Science of Mental Health. The Church claims 5 million adherents to its self-help philosophy. The Church of Scientology has called itself the spiritual heir of Buddhism in the Western world, and focuses on what it calls pastoral counseling, from children, by the way, everyone, to increase its members' abilities and awareness. But in the past few years, the Church has been accused of brainwashing and harassing its members, and it has become embroiled in dozens of lawsuits. See sidebar, page 32. Including the 1978 criminal conspiracy charges against 11 of its members. Isn't it funny they didn't charge Scientology, the organization? Isn't it strange, you guys? Such setbacks have triggered increasingly militant responses, which focused in the conspiracy case on the federal judiciary. The Scientologists' legal strategy has been to force the recusal of judges, against the law, by the way, but lie at the root of the pending criminal charges against the Scientologists. In 1976, D.C. District Court Justice George Hart Jr. casually proposed a deposition of Hubbard in conjunction with one of many Freedom of Information Act suits filed by the Church. Hart's remark, "No deposition ever proved necessary," caused Scientology officials to believe that the government knew something incriminating about Hubbard. As a result, the Church intensified its efforts to learn what information the government might possess. At the same time, the Church was issuing Guardian Program orders. Wonder what Rindy knows about that. Directives to church members telling them to use standard overt sources and any suitable guise interviews to monitor the activities of all district court judges presiding in the FOIA suits. In 1977, that directive was extended to all 15 active judges in the D.C. Federal District Court. Posing in some instances as students and journalists. Isn't that also against the law? FBI? Department of Justice? Scientologists interviewed the judges, researched their careers and backgrounds, followed them, and prepared dossiers. Kind of like other government agencies, but I digress. According to Scientology documents, their goal was to determine tone level and buttons on, indicia of personal vulnerability. I think that's supposed to be indication. In the parlance of Scientology, but the Church's operation went far beyond legal surveillance. Members of the Church were caught breaking into the offices of the IRS and the Justice Department, stealing and copying documents, and eavesdropping. Isn't that also against the law, everyone? On August 15, 1978, 11 Scientologists were indicted on charges of electronically intercepting oral IRS communications. No mention of the Scientology policies. that spurred the unlawful breaking of the law. Weird, huh? Forging government passes, illegally entering government buildings, Mr. Agent Man, recruiting Scientologists to infiltrate the government. And they do it in all these countries, but so little happens. Isn't that weird? Stealing records belonging to the IRS. Isn't that a federal crime right there? Justice Department, gotta wonder, is it really Justice Department? And the U.S. Attorney in conspiring to illegally obtain documents in the possession of the United States and to obstruct justice. The Scientologist defendants hired some well-known defense counsel. The ones not named here, of course. Mary Sue Hubbard, the wife of church leader L. Ron Hubbard, and the highest-ranking defendant on trial, retained Leonard Bowden of Robinovitz, Bowden and Standard, practicing law in New York City. Two other defendants, Henning Helt and Duke Snyder, retaining Alexandria, Virginia lawyer Philip Hirschkopf, who had been counsel for the DC-9 anti-war protesters arrested in 1970. Isn't it funny how the protesters are the ones always getting arrested? Isn't that weird? COINTELPRO. Arrested in 1970. In all, 12 lawyers were hired to defend 9 defendants. 2 others had fled to England. Isn't that also against the law, you guys? What is that called? Fleeing? Fled to England, where they faced extradition proceedings. Bowden and Hirschkopf soon assumed the leading roles in the defense. If we really wanted to go down the rabbit holes, it'd be interesting to see what happened to some of those lawyers down the road after, their involvement with Scientology. Bowden and Hirschkopf won't discuss why they were selected. Cha-ching. But their public identification with radical and unpopular causes was undoubtedly attractive to church members. Don't you guys wonder if some of these lawyers are maybe working for the government? You ever think about that? It's just a question. One lawyer who represents Scientologists and has worked with Bowden and Hirschkopf. Okay, I'm sorry. This was Bowden's first association with the church, allegedly. But Hirschkopf had handled a search and seizure matter for the church in 1977. One lawyer who represents Scientologists and has worked with Bowden and Hirschkopf offers this ideological defense for their taking the case. It is a simple case of government overreaching, he says. The government just can't tolerate an organization with non-conforming beliefs. Notice he didn't say church. The Scientologists stand up for their rights. Isn't that the irony of the century? Aggressively. Another lawyer who has worked on the case adds a financial motive for their taking such a case. Of course. Remember that LAPD cop? It's good money. These people pay their bills, anything for money, top dollar and on time, which is more than I can say for most of my unpopular clients. This case will finance a lot of pro bono work. Hirschkup won't say what he has received in legal fees from the Scientologists. But the church is a prosperous client. Prosperous on the backs of child slave labor and adult slave labor. But the church is a prosperous client. In one instance, a member paid the church $30,000 for the required series of counseling sessions. Notice that, required. Don't you guys wonder if the kids were auditing them too? We all know the answer. Snakes in the grass. I mean, snakes are cool, but you guys know what I mean. Bowden filed the first recusal motion in January 1979. His theory was a novel one, by telling Judge Hart that the judge himself was a target of the Scientologists' own possibly illegal activities. He would cause the judge to be biased. Where have we heard that word before? Or appear to be biased against them. In his motion, Bowden quoted a Scientology document ordering an overt and covert data collection operation against Judge Hart. Which, in Bowden's words, possibly included the use of methods violative of the judge's privacy and other rights, and possibly violative of the criminal laws. Bowden concluded that the sitting judge is revealed to the jury and the public as a victim of possibly illegal actions, and the judge has an obvious interest which may be affected by the outcome of the case, notwithstanding documents to which government and defense counsel had access, ordering similar operations on all the District of Columbia District Court judges. Bowden declared that he knew of no other such campaigns. Although government lawyers, led by Chief Prosecutor Raymond Bownen, protested vigorously, arguing that the Scientologists were using their own possibly illegal activities to disqualify the judge, Hart granted the recusal motion and stepped down. Interesting. Hart denied that he was biased, but he agreed that the appearance of impartiality had been tainted by the Scientologists' surveillance operation against him. I was afraid a jury would be prejudiced against the defendants because of their alleged threats against me, Hart said recently. The case was assigned next to Judge Louis Oberdorfer, who, in light of Judge Hart's recent experience, asked for memoranda and oral arguments from both sides of the outset, indicating potential grounds for disqualification. Government lawyers pointed out in their memo that Oberdorfer was formerly an assistant attorney general. There you go, you guys. Wakey, wakey. In charge of the tax division of the Justice Department. Which had prosecuted a case that ended the tax-exempt status for the founding Church of Scientology in Los Angeles in 1969. Oberdorfer concluded that he had personal knowledge of disputed evidentiary facts And on February 5th, 1979, he too stepped down. Do you guys wonder if he was being fair gamed? Shortly afterward, the case fell to Ritchie, 57, a 1971 Nixon appointee, whose liberal record, especially in the area of defendants' rights, surprised early critics. The assignment initially pleased the Scientology defendants. In a pamphlet called The Trial of the Scientology Nine, you guys know 9 is a very significant number. And I'm going to say it once, and that's it. 9 is symbolic of Satan, facts. I'm not saying that was here, but, you know, it's known in a lot of circles. Prepared by the Scientologists, Judge Ritchie was described as having a very fatherly visage, though crippled with a congenital defect in his hip. One does not notice either his limp or his shortness. His glasses, glinting from the lights of the courtroom, add to the picture of a man of deep intelligence and sympathy. And when Ritchie, too, asked at the outset for a recusal motion, if one were planned, Bowden and Hirschkopf said they were satisfied with his assignment to the case. That attitude was soon belied by a campaign of harassment that took place in and out of the courtroom. How about that, Clearwater PD? During the summer of 1979, court sessions were held for about 3 weeks in Los Angeles, where Ritchie scheduled testimony on the Scientologists' motion to suppress evidence seized by the FBI. Huh. Seized by the FBI. How interesting. In its 1977 raids of the church's headquarters, the thousands of documents seized in those raids, I wonder if there were PC folders talking about children being AR'd. Don't you guys wonder? I would say probability's pretty high, that one. Don't you guys think? In those raids constituted the core of the evidence against the alleged conspirators. The hearings had been moved to Los Angeles to accommodate the Scientologists' witnesses. Prior to his departure for Los Angeles, Ritchie received several death threats. Hey, you guys, is that like giving a judge a death threat? Isn't that like pretty steep sentence for people? Or criminal organizations like the Mafia or Scientology? Inquiring MF minds just want to know, you know? Received several death threats. Hold on, guys. The judge has never publicly alleged that those threats came from Scientologists. Weird. And has said they were unrelated to the case. But he flew to California escorted by 2 federal marshals. Interesting. Too bad the little kids getting AR'd in those auditing rooms and in the basements couldn't be protected by 2 federal marshals. And elaborate security precautions were implemented at the federal courthouse in downtown Los Angeles. During the hearings, defense lawyers repeatedly interrupted the proceedings. Where have we seen that before? With objections, motions, and audible commentary, including insults to the judge. Isn't that also against the law? And there were no arrests made? Wakey, wakey, everyone. For example, Hirschkopf and other counsel repeatedly and loudly ordered co-counsel to place adverse evidentiary rulings in a mythical error bad. On several occasions, Hirschkopf accused Ritchie of lying. At times, Ritchie left the bench and walked out rather than hold defense counsel in contempt. Why is that? Does anybody wonder why the fuck that would be? Only once at a later hearing did the judge seem to boil over. Speaking to Hirschkopf, Ritchie said, "I want to tell you right here and now, I resent it because I have done nothing to hurt you or your clients. And this record is replete with insults and everything else, when I have not done it to you and don't intend to. But now, the prosecutor says Ritchie was too accommodating. Don't you guys wonder why that would be?" He should never have tolerated such behavior, but now says, kind of like Clearwater PD. Hirschkopf claims that he was the one who insulted. "Ritchie showed contempt for me," Hirschkopf says, recalling the time when he claims Ritchie tried to force-feed him French fries in court. Benown says, that's a 6-6, by the way, he had not finished at lunch. I mean, I'm not saying that necessarily it was 6-6, but I can't help myself. "I called Benown a liar," Hirschkopf continues, "and the judge admonished me, but Benown could insult me with impunity." Sounds very narcissistic. Benown denies that this was true. Hirschkopf concedes that he frequently became heated in his dealings with Judge Ritchie, but says, "I never called him dirty names." What do I always talk about? Birds of an MF feather. Go look into the case where the sheriff, SHOT, the judge, dead. Go look into that. Viking mindset went in. In September 1979, after the Los Angeles hearings, Ritchie denied the Scientologist motion to suppress the evidence seized by the FBI. Interesting. The defendants eventually entered into a stipulation of facts, which amounted to an admission of the principal charges against them, and waived a jury trial. In return, the government agreed to drop 23 of its 24 criminal counts. That's a 33. I mean, if that's the case. Hold on, guys. Judge Ritchie explicitly warned the Scientologists that the stipulation was likely to result in their conviction. He subsequently conducted his own review of the evidence, which he said was overwhelming evidence of guilt. And on October 26th, he convicted all 9. Notice nobody went after the organization or organizations, corporations of Scientology. Isn't that interesting? On December 6th, 2 days before they were to be sentenced, a recusal motion against Ritchie was filed. In this recusal motion, Bowden and Hirschkopf again took the extraordinary position that Ritchie's response to their courtroom tactics and to the threats showed that Ritchie was prejudiced against Scientologists. This is hard to follow. For example, without saying that the death threats were made by Scientologists, Hirschkopf said that upon information and belief, the security in Los Angeles was related to the court's apprehension with regard to the defendants in this case or the church, adding that it is impossible to imagine a stronger or more clearly extrajudicial source of bias than fear for one's life or well-being. Whatever its merits, the recusal motion was patently defective in at least two technical respects. The judge recusal statute required a timely motion supported by an affidavit signed by a party. This motion was filed 4 months after the events complained of, and after nearly 120 defense motions had been resolved against the Scientologists, and was supported by Hirschkopf's affidavit. Not one of the defendants, I should have filed it much sooner, Hirschkopf concedes. Ritchie was grossly prejudiced from the start. In response to the motion, Judge Ritchie defended his security precautions, noting that the court may accept reasonable security precautions without risk of tainting its rulings in the case. He denied the motion and that same day sentenced the 9 defendants to prison terms of from 6 months to 4 to 5 years. Notice there was nothing to state, let's put a hold on Scientology policies. Interesting. Eight pulled out checks for $10,000 the day of their sentencing, and all 9 are now free on bail pending appeal. The denial of their first recusal motion and the sentences, which the Scientologists regarded as unconscionably harsh, led to a redoubling of defense efforts to drive Ritchie from the case. 6 months later, in June 1980, defense counsel were ready with another recusal motion, more damaging and threatening to Judge Ritchie than the first. The groundwork for that motion had been laid nearly a year before, shortly after the Los Angeles hearings. That summer, Thomas Dorian, Judge Ritchie's official court reporter who accompanied him to Los Angeles, was approached by Hirschkopf soon after the return to Washington. In a sworn affidavit filed in response to the second recusal motion, Dorian says Hirschkopf wanted to know if the security precautions in Los Angeles resulted from Ritchie's fear of Scientologists. It's fear of Scientology, it's not just Scientologists. Scientology is an entity. In the affidavit, Dorian swore he denied that the judge was afraid, but confirmed that before leaving Washington, the judge and his wife and 2 sons had received 2 death threats. Isn't that usually enough evidence for some arrests? I don't know, maybe I'm slow or something. Soon after this encounter in December 1979, a Scientology lawyer hired Richard Bast, a private detective who had worked for Hirschkopf several years before, to investigate Judge Ritchie's security precautions. Did you guys wonder what Rinder was involved in this one? I do. Rathburn. Bast's fee, $321 plus expenses. One of Bast's first steps was to infiltrate Ritchie's inner circle at the courthouse. In the spring of 1980, a few months after the Scientologist sentencing, Fred Kane, a Bast employee and retired police officer, a Bast employee and retired police officer, approached James Perry, one of the 2 U.S. Marshals who had accompanied Ritchie to Los Angeles. Kane explained to Perry that he had been retained by an European industrialist whose daughter had committed bluicide, allegedly as a result of her involvement with the Church of Scientology. I wonder whom that was. There are so many bluicides, especially of the women. Weird, huh? And that his assignment was to uncover information that could be damaging to the church. According to Bast, Perry told Kane that he wanted to write a book on the Scientology case, and Bast offered him a $2,000 advance. Bast says that Perry took the money and they agreed to work together. The evening of May 23rd, Perry and Kane met Dorian, the court reporter, at his home in Washington. According to Dorian's affidavit, Kane introduced himself as a private investigator for International Investigations Incorporated, Bast's detective agency, and told him the same story about the European industrialist. Dorian says in his affidavit that he found the story improbable, but that because his home had been burglarized and he had received threatening phone calls, which he suspected came from Scientologists, he was curious about what Kane and Perry were doing. According to the affidavit, Dorian met with Kane 3 more times, and each time he was questioned about Judge Ritchie. At a meeting at his home on May 31st, 1980, Dorian says he realized that the conversation was being recorded. Kane had been drinking heavily, Dorian says, and as a result, the court reporter was able to slip a small tape recorder and 3 cassettes out of Kane's pocket. Dorian's last meeting with Kane was on June 19th, when they met with Bast, I think isn't Bast the ex-cop, and then dined at a nearby Pizza Hut. Again, Dorian was asked about Ritchie, and the conversation was recorded. The recordings of Dorian, along with tape-recorded statements made by Hirschkopf, all collected by Bast, form the basis for the next recusal motion against Judge Ritchie. The motion, largely incorporating an earlier recusal motion filed by Hirschkopf, was filed on June 20th, 1980, as proceedings were beginning against the 2 defendants, recently extradited from Great Britain. For some of the Scientologists' counsel, however, the recusal strategy had gone too far. There was apparently opposition within the ranks to these motions and the way they were prepared. One lawyer, Michael Nussbaum, who represented 2 of the defendants, didn't sign the papers and withdrew as trial counsel. Maybe he was afraid he was going to lose his law license? I mean, we can hope, right? The affidavit in support of this motion was filed by Morris Budlong, one of the extradited defendants. After he listened to various tapes and spoke to Hirschkopf, among the prejudicial remarks that Budlong attributed to Judge Ritchie were that Ritchie's death threats emanated from Scientologists, that Jim Jones and Scientologists were all the same, that it would be a feather in his hat to convict the Scientologists, and that Ritchie had told another judge that Scientologists were spreading rumors about him as part of a plot to discredit him. A cryptic footnote to the affidavit declined to provide details of the alleged rumors about Ritchie, citing respect for the court as an institution. But Hirschkopf and other defense counsel knew the details of the plot Ritchie alluded to. They had gotten them from Bast, who says he had combed the Los Angeles area, for information about Judge Ritchie's personal habits, interviewing motel and restaurant employees, and making videotapes and recordings. The information not revealed in the motion was taken by Bast to political columnist Jack Anderson. The central figure in Bass's story was a self-professed Los Angeles prostitute who worked the Brentwood Holiday Inn, the motel where Richie stayed during the Los Angeles hearings. In a video recording shown to Gary Cohn, a reporter for Anderson, the prostitute recalled in titillating detail, according to Cohn, an encounter with Judge Richie at the motel and his procurement of her services. According to Cohn, Bass also showed results of lie detector tests conducted by Kane to demonstrate that the prostitute was telling the truth. A tape recording of Perry, the U.S. Marshal, claiming, Judge Richie said, "Let's go get a woman." And a tape recording of Dorian, the court reporter, saying Richie was always picking up girls. Cohn says that he was initially skeptical of the story because he was aware that Bass was employed by the Scientologists. But he says that he had often worked with Bass and trusted him. He says he considered but rejected the possibility that the prostitute was herself a Scientologist, planted to entrap the judge. Yeah, like a honey, what do they call that, the honey pot? Bass says only that his discovery of the prostitute was accidental, that he paid her $1,200, that she is not a Scientologist, and that she is no longer streetwalking. I mean, it could be true. It could be true, but I wouldn't put it past him to set him up. We know that happens all the time. Cohn says that he was initially skeptical of the story. Already read that. Cohn wrote the column, which later appeared under Anderson's byline, focusing on Bass' investigation and Richie's procurement of a prostitute, because we all know cops never do that, right? Cohn adds that he is now not happy with the way the column was written. In his affidavit, Dorian, the court reporter, who has heard the tapes he stole from Kane's pocket, denies the remarks attributed to him. Newspapers that subscribed to Anderson's column received the Judge Richie story around July 11th, a week before its release date of July 18. Some of them balked at running it. The New York Daily News decided not to publish it, and the Washington Post used it only after extensive conversations with Cohn. Cohn says he never reached Richie for comment, and although Post editor Ben Bradley says he is sure we did call Richie about the column, no comment from Richie appeared in the Post's version either. On July 16th, Richie issued his opinion, evidently referring to the upcoming Anderson column, which Richie might have known about from reporters' calls and messages. Richie characterized the recusal motion as this latest effort in the escalating attack on the court, and found the grounds for the motion to be insufficient as a matter of law, resting only on hearsay, rumor, and gossip. Kind of like what the Clearwater PD does in regards to Scientology, some of them. But the judge continued, defendants and their counsel have engaged in groundless and relentless attacks on this court. Their motive is transparent. It is an attempt to transform the trial into a trial of this judge, though he labeled the attempts to remove him a classic example of abuse of the recusal statutes. He wrote that the time had come for the proceedings in the case to proceed on the merits with the attention of all directed at the real issues in the case. As a result, Richie withdrew from the case in a state of exhaustion and near collapse, according to associates. Yeah, fair game bees like that. You'd think it'd be like a federal crime to go after a judge, but, apparently not. How is this any different from the Italian or the Irish or the African-American mafias we have? Colombian mafia? How is it any different? On July 18th, Jack Anderson's column appeared in newspapers throughout the country. 5 days later, Judge Ritchie was hospitalized with exhaustion and pulmonary embolisms. He has since declined all comment on the case, citing the Code of Judicial Conduct. Wow. Judge Ritchie's ordeal may not be over. Hirschkopf vows that his campaign against the judge will continue. Oh, what is the policy, you guys? The LRH Scientology policy that talks about you just keep going, and if it results in death, it doesn't matter. I don't remember what the name of it is. It's in black and white writing. Against the judge will continue, and he claims that the prostitute affair is only the tip of the iceberg. Although Hirschkopf declines to disclose details, he says if necessary he will expose additional damaging information uncovered by Bast. You guys should ask yourself, how is this allowed to go on? But we all know it does. We're living in a very evil, 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 dark world. Apart from the delays, the campaign against Judge Ritchie has had negligible legal impact on the proceedings against the Scientologist defendants, though an appeal is pending on a conventional search and seizure question. The convictions of the first 9 stand. Trials of the remaining 2 defendants started in late October under Judge Robinson and are still in progress. The activities of the Scientologists and their counsel in this case seem destined only to satisfy a commandment. L. Ron Hubbard once wrote, oh, here it is, you guys. The defense of anything is untenable. The only way to defend anything is to attack, like Mike Rinder. And if you ever forget that, then you will lose every battle you are ever engaged in, whether it is in terms of personal conversation, public debate, or a court of law. Never be interested in charges. Do yourself much more charging, and you will win. I mean, it just shows you little Moxie didn't even care about his own daughter. He'll use her to make people feel sorry for him, but it's obvious to me, in my observation, Moxie didn't care about his daughter. That's obvious. In its July 1980 issue, the American lawyer named Judge Charles Ritchie runner-up to the worst District of Columbia federal district court judge. The lawyer who most vehemently denounced Ritchie was one of the Scientologists' defense counsel. Wow, unreal, you guys. And the same lawyer also referred our reporter to other lawyers who have represented Church of Scientology defendants. You guys see why talking to LAPD is just deaf. You're falling on deaf ears. It's my opinion. To me, it's a waste of energy. Also referred our reporter to other lawyers who have represented Church of Scientology defendants. Isn't that wonderful? The reporter, who has since left our staff, says he was unaware of Scientologists' efforts to discredit and recuse Judge Ritchie. Without the lawyer's vehemently derogatory remarks and his referrals to other sources, our reporter says he would not have named Ritchie in the survey. Yeah, that reporter is partly responsible for some of this, in my opinion. Battles on other fronts. The Church of Scientology has been involved in almost constant litigation since its founding nearly 30 years ago. Besides periodic clashes with the government, the Church has filed scores of suits against the media to inhibit the news coverage of its activities. You guys, what is the law for media representation? Not the law, but the amendment. I can't think of it. Right to free media coverage or something. Among the more recent cases involving the church and the media, 14 libel suits have been filed against Paulette Cooper, a New York freelance writer, an author of the 1971 book, The Scandal of Scientology, and her publisher. Church documents seized in the 1977 Los Angeles raid and made public last year revealed Operation Freakout, a campaign of harassment directed against Cooper that included DEATH threats, obscene phone calls, phony letters about her sexual behavior, and a forged BOMB threat against the church that resulted in Cooper's indictment in 1973. The charges against Cooper were dropped in 1975. Cooper is now retaliated with a $55 million suit against the church. A 1977 suit against the San Diego Union asked $10,000 in damages for invasion of privacy from a reporter who had registered for a Scientology course in order to write a story about the church. The church offered to drop the suit if plans to publish the story were dropped. But after the story ran, the church increased its damage claim to unknown dollars and added charges of fraud and deceit against the paper. The case was dismissed on summary judgment. In 1976, the church sued the Clearwater Sun in Florida for $1 million and threatened to sue the St. Petersburg Times for a series of stories on the church. Scientologists spread rumors, the smear campaign, linking Times officials to the Charlie Igloo Alpha. So much deeper than that. Yeah, you guys ever wonder what L. Ron Hubbard's obsession with the Charlie Igloo Alpha was? Huh. Let me see. Didn't Anton LaVey and what's the other guy's name? The major who wanted to get Satanism into the military. And weren't they all involved with the Charlie Igloo Alpha? Huh. The FBI and the Communist Party and harassed reporters. The Sun countersued the church for abuse of process. And the Times sued for an injunction barring the church's harassment of its reporters. Don't you wonder what Rindy knew about all that? The church subsequently dropped its suit against the Sun and never followed through on its threat to sue the Times. In March 1979, the church sued two New York writers, Jim Siegelman and Philo Conway, after they criticized Scientology on the David Susskind show while discussing their book, Snapping. After the Scientologist suit against them was dismissed, the pair countersued, charging the church with malicious prosecution. The church has lately found itself on the defensive in a flurry of suits filed against it by disgruntled former church members and recruits. Currently pending against the church are a suit filed October 21st by Lawrence Stifler, a Boston Marathon runner, asking $41.25 million for damages sustained after he was allegedly physically attacked by a Scientology recruiter. I don't mean to laugh. That's crazy. We saw that right at the on Hollywood Boulevard, the recruiting center. All that crap we saw. Little towelmen who can't even sing. All the bought off, in my opinion, LAPD officers. It's just disgusting. After the Scientologist suit against them was dismissed, wait, where am I here? Stifler says that due to the injury, he may never run again. Can you imagine, you guys? It's freaking sickening. I mean, even if whomever was attacking that guy, if those idiotic Scientologists woke up and got out of Scientology, they still need to be held accountable. They can't just walk out just like little Rindy and Rathy and act like, oh, they're so innocent. Oh, they're so innocent. They don't know anything about the Mercs or the assisted bluicides. We all know the R245s. Flo Barnett. You guys wonder why Dave Miscavige's twin sister's like really into marijuana and stuff and all the stuff she's going through? Come on. It makes me sick. A $16 million suit filed in April by Tanya Burden, a 20-year-old former church member who claims she was deceived and forced to remain in the church, used as slave labor, and kidnapped after she escaped. Imagine the Clearwater PD and all these other bought-off police officers are just fine with it. I'm not saying all of them are in on it. We know the dirty cops. Pretty easy to see them. A $21 million suit brought by jazz guitarist Gabor Szabo in February, accusing the church of embezzlement, kidnapping, and forcing him to undergo a life repair course. A class action filed last December by former church staff member Lavenda Van Schack, seeking $200 million on behalf of church dropouts. Her suit accuses the church of mind control. Wonder what the Charlie Igloo Alpha knows about that, don't you guys? Hint. Of mind control, unlawful electronic surveillance, and leaking details of her private life to the media. Last year, Julie Tichborne, a former Church of Scientology member, was awarded $42 million by a Portland, Oregon jury, which found that the church's promises of a better life were fraudulent. The church has subsequently sued 4 deprogrammers for $2 million, collectively claiming that they induced Tichborne to turn against the church, JBS. I will leave a link in the description box. Like and subscribe if you choose. Otherwise, have an amazing day or night wherever you are. Peace.